So we are starting with our session, fourth of the day. Trademark is querying, protecting trademark across borders. And the speakers for these sessions are Henrietta Newton-Martin, Legal Manager, United Nations, UAE, and Richard Milchoir, Associate Lawyer and Partner, Herald, France, Sergei Medvedev, I'm sorry about that. Partner, Head of Legal, Gorozhsky and Partners, Russia. Elizabeth Kirioni, the Kirioni Trademark Detective Bureau, Russia. So I'll introduce Henrietta so that you can start with that. So common law qualified lawyer with years of experience in practicing law in UAE, Oman, MEA, and India, specializing in cross-border litigation and legal advisory. Serving as an in-house counsel for legal matters, ability to render strategic advice on company policy, HR policy, CSR, producers, contracts, and legal documents spanning across areas such as litigation, dispute resolution, and arbitration, airports and aviation law, construction, PPE, IT, corporate and commercial laws, international laws. Possesses core competencies in building key alliances and partnerships with stakeholders, ministries, and government entities. Experienced in handling cross-border litigation and cross-border disputes, industry expertise spans academia, government projects, aviation, PPP, food industry, IT, hospitality, production, and manufacturing sectors. I think it's a long list. So here is Henrietta, and she'll take care from here. Thank you.
Well, greetings, everyone. I'll try my best not to make it soporific. As it is, you'll have come back from a lunch break. So I understand that, even I have. So I'll try to keep it succinct as well. Well, I think the first thing is to get acquainted to the podium. Well, as you can see on your screen, our topic for discussion for this particular slot is trademark squatting and cross-border protection. This is Henrietta Newton-Martin, as he, at length, introduced me, senior legal counsel and faculty member. I'd like to begin with an interesting quote by Blaise Pascal, just to begin it, on a lighter note. Blaise Pascal is one of my favorite philosophers, of course, and he's said to have remarked once, "What a chimera then is man! What a monster! What a novelty! What a chaos! What a subject of contradiction! What a prodigy!" He says again, "A feeble worm and both, the pride and the refuse of the universe." And to that, I would like to add and ask, what is law if there is no impact? And what is law if it does not meet its purpose? Well, you will see a colorful slide that is going to be vibrant and just wake us up. I've seen throughout the sessions like it has been monochromatic or something in beautiful colors, light colors, but I've kept it deliberately, colorful, because I like the world of colors. Well, and to be precise, in fact, just to draw your attention towards key points. Well, so what is law again if it does not meet its purpose is my question. And over the years, what has been done in trademark squatting, if I may ask? I'm sure it may not flabbergast some of you when I say that in recent years, trademark disputes have become a subject for corporate war, with corporate giants battling their way out of trademark misuse and abuse. And of late, there is this trademark squatting, which has raised its ugly head over the years. So you have a number of legislations in different laws, domestic legislations, and we have, of course, our WIPO, WIPO treaties and conventions. I'm here among eminent IP lawyers and counsels. If I may ask them, just to recall, so that probably during the end of the session we can have the question and answer round, and maybe from there we could take it vibrantly. But I have a question. Have you read the WIPO 6 treaties and conventions meticulously. I have done it, okay? And I want to know, are you satisfied as legal counsels, in-house counsels, specializing in IP, whether it addresses trademark squatting? Of course, you might say trademark abuse, it's well covered. Trademark misuse, yes. Trademark infringement, yes. But trademark squatting, you might say, what is the difference? I'll explain to you. So let's keep this at the back of our mind and then proceed with our slides. Let me begin with the Apple story, just to set the perspective. Of course, again, all trademark lawyers will know the citation very well. That is RXD Media LLC versus IP Application Development LLC, number 191461, Fourth Circuit. I have given the entire citation just to help you. If you want, you can jot it down because it'll help you in fortifying your arguments before any tribunals in case you're representing your company. Well, this is a classic case of trademark squatting. And just to let you know the story, in fact, you already know it. In 1990, Apple launched, what did it launch? iMac. It launched a series of iProduct and I meaning internet products. It launched iMac, iBook, and of course, your laptop and desktop. Then moving on to 2001, Apple launched the first generation iPod, a handheld music device which was clubbed with iTunes, which we all boasted of, during the teenage years. And then in 2007, Apple launched its first iPhone. Then, while Apple was booming, this much celebrated iPhone, of course, it was booming with its iPhone, RXD launched a mobile internet notepad. I'm reiterating, RXD, there was a new competitor which came up in the market, and it launched a mobile internet notepad called an iPad Mobi. If you notice on the screen, the letter I is capital here. And Apple uses the small letter I. Well, what's the purpose of an iPad? We all know, again, it's just jotting down points, making notes. And in September 2007, RXD launched its website detailing the product. But again, as we all know, there is nothing like Apple. And RXD really did not become a commercial hit. Then in 2010, Apple launched this so-called controversial device called the iPad. Mind you, it launched the iPad, which is again a touch screen tablet, and simultaneously sought the intent to use trademark under the Lanham's Act, USA, for the iPad mark, and filed relevant applications. I think it's 463 or 543, something, and with the US State Patents and Trademark Office. And Apple also engaged, as usual, as any corporate counsel would advise their IP team to do, series of other iPad registrations, of which, of course, the Fujitsu Incorporation registration was also done. Long story short again. Now, RXD filed its trademark applications also in 2010 before the US Patent Office, and its application was thrown out or rejected. Now, of course, it threw... RXD was irate about this, and it launched adversary proceedings against Apple. Now, RXD's contention was that Apple's use of the mark constituted unfair competition, and RXD flouted the principle of first user. Now, again, IP professionals would know what is a first user principle. First to file, first to use, I'm sure you know that. That is, first to use is a principle that is used by the common law jurisdictions, and first to file is invoked by the civil law jurisdiction. Well, so Apple, now again, what was the contention of Apple? Apple contended that RXD had the intention of confusing its consumers. I want you to listen to this, precedent carefully, because there's a certain reason, and I'll draw your attention to the types of trademark squatters as well. So RXD, I'm reiterating, had the intention, Apple says, that of confusing its consumers. Again, long story short, the court of appeals, there was Justice Keenan there, and he held in favor of Apple and said that Apple indeed had a bona fide intent to use the mark and the services listed in its application. And reports say that Apple had to expend approximately $3.6 million to get the trademark back. Now, thereby, what is this trademark squatting? Of course, it's also called as trademark piracy, and it simply means unauthorized use and registration of a trademark or a brand that primarily belongs to someone else. In some cases, a squatter may also register a trademark with the intention to even extort money or even to launch a counterfeit product. So that makes a trademark squatter as a counterfeiter. It makes the trademark squatter as an extortioner. It also makes a trademark squatter as a copycat, it may be intentional copycat or an unintentional copycat. So what are we referring to here is just not mere trademark infringement or mistaken filing, but a deliberate attempt to file or register a trademark in some other country. For instance, Apple again. This is yet another case. When its trademark iPad was not registered in China, it had to shell out $60 million to get back its trademark iPad from a Taiwanese company, a Chinese subsidiary called ProView. Now, there are two important factors to be considered while resolving a trademark case, which again the lawyers would know. The two I's, that is the intent, the intention of the trademark squatter, making it easy, the two I's, and two, the impact. When any case comes before a lawyer, they see the two factors, the intention as well as the impact. Now let me substantiate this with a Samsung's case. As reflected in the famous Samsung's case, Samsung applied for an EU trademark, where the gentlemen here are quite distinguished in that field, for an EU trademark, registration of trademarks in the European Union in 2016 to protect the name of its new new phone application called Bixby. And this was opposed by the Pakistan registrant of the Bibi trademark. So he used the trademark Bibi. Later, he registered it in the Benelux region of Belgium, Netherlands, and Luxembourg. So in this case, again, the court invoked the doctrine of bad faith. Again, the long story short, the High Court of Hague held in favor of Samsung, adjudicated in Samsung's favor by nullifying the Bibi trademark and ordered the trademark squatter to pay Samsung's legal costs, and said that Bibi trademark was indeed, or that Pakistan registrant, in fact, had a malicious intention of using or registering the trademark. So as every legal practitioner knows, I would like to reiterate this. There are two principles, just to brush up our memory, that the principles that are invoked depending on the jurisdiction is the first to use principle, where usage plays a prominent role, or it is a significant factor in determining the brand owner's right over a particular mark. And the next one is the first to file, which is used in civil law countries, like, of course, even we here in UAE, or even, I guess, Paris, civil law countries, they use first to file, and India uses first to use. Common law countries use first to use. Now, civil law countries, of course, they use first to file, which means that registration may be granted to a brand owner just by way of mere registration, and then he gets an enforceable right. Just when he files the application for a trademark, who first files it? Now, what about UAE? Now, a proposed UAE VR I'll go slow here. We are a civil law country, of course. I mean, we use certain principles. Okay. So we use the principles from the civil law jurisdiction, and the most recent promulgation here is the 2021 trademark law number 36 of 21, which explicitly forbids forging. The term used here is anyone who forges. The UAE law does not specifically mention trademark squatting, or squatting, however you pronounce it. It does not mention that word, but it uses the word forging. So that means it interpretatively includes squatting. And this is a commendable legislation in the recent years, and in UAE we are in the process of developing the laws, and we are getting there. And this particular law, it talks about or inflicts penalties on anyone who forges the law or uses a forged or a counterfeit trademark for commercial purposes. And the penalty imposed under the law, the pecuniary penalty, is AED 100,000 to AED 1 million or an imprisonment for 1 year. The most interesting provision for me, as per this law, is Article 50, which further conveys that whoever sells or offers for sale or circulation or possesses with the intention of selling goods or offers the provision of services carrying a forged and imitated or unlawfully put or used trademark despite his knowledge thereof. That means even if I use a trademark, just which is sold to me, and I know it is a forged one, and I kind of keep mum about it, and I use it discreetly, even then there will be a penalty that is imposed upon me, up to a pecuniary penalty of AED 50,000 up to 200,000, and an imprisonment can be up to 1 year, or fine, or both. Now, depending on the facts and circumstances of each case, the jurisdiction and the client, again, may be advised to file a civil suit as well as a criminal charge. Now, this is something to think about, what UAE does here. A civil suit and a criminal charge. Now, here, civil suit, for lawyers, of course you know about this, civil suit and a criminal charge in UAE does not work concurrently, right? But in India, a civil suit and a criminal case can go together. However, the court may file an application saying that let the civil suit be stopped till the criminal case is adjudicated. Now, further, UAE is interestingly a party of several international treaties relating to intellectual property. Of course, the famous Madrid Protocol. Then, apart from that, is the Bern's Convention, the Paris Convention, the Rome Convention, the WIPO Convention, Copyrights Treaty, the Patent Cooperation Treaty, TRIPS Agreement, and so on. I would like to draw your attention also to the fact here about the Paris Convention. And there's a reason for this. I'm sure you know, being intellectual property experts, that the Paris Convention was actually the one which prompted the advancement or the setting up of WIPO. So the Paris Convention was actually convened way back in the 1800s. Now, Article 6 bis, that is a clause that is interspersed between Article 6 and the next article, Article 6 bis of the Paris Convention, and Article 16 of the TRIPS Convention explicitly details about trans-border reputation. We heard this morning about the principle of trans-border reputation. So this principle is actually, again, a significant element and provides that if a mark has not been used in a specific country, but has established reputation in that country as a result of international usage the trademark may be protected in that country. Now again, we have legislations, we have conventions, we have clauses, we have even WIPO clauses, but how far it is effective, even in the light of this particular principle, which is, again, a clause which is interspersed between 6 and 7 of the Paris Convention, and of course, even Article 16 of the TRIPS Agreement. So what's the solution? Living in a world which is set to have no borders when it comes to business and trade, what is a solution to the risk of trademark squatting then? Through the sessions, we have been hearing about, different ways of resolving trademark infringement, trademark disputes, what can be done after we are attacked. So my question is, what can be done before you're attacked? And what can be done, in fact, to obliterate trademark squatting? What has to be done about it? Some may feel that, well, what you are talking may not be practical enough. But in my humble experience of few years, of course, unlike some of you who are much senior than me, I just hold around 17 years of experience, where some of you may be in 20s or more than that. In my personal experience, a lawyer, an in-house lawyer, can play a very important role in curbing or even in obliterating trademark squatting. Now, the thing is that we need to discourage the menace of trademark squatting and not just prevent or implement solutions or advise solutions as a victim or for a victim. Now, some lawyers, you already know this again, some lawyers advise, if you ask any lawyer, in my experience, because in my circle, if you ask any lawyer, at least from China, at least, so when you ask them, what do you think is a solution to obliterate trademark squatting, sir? He says, no, come and register your trademark in China. Why? Because, there are apparently many cases which are rising from China. So if you register your trademark in China, then of course it would be one of the principles to, they didn't use the word obliterate, but they said that you can just shut the door to the enemy. But for me, again, in my humble experience, reiterating, that's not the solution. Because why? I have been into policy making. The little that I do to protect my company in whatever field it is, I devise policies for my company in the way that its trademark is protected. Its trademark is, it is not attacked, or just not trademark. Let it be trademark, or let it be even HR policies or CSR policies. And I believe in practical implementation of things and not just a beautiful story. You see, so lawyers can play in-house counsel, but whatever position you may hold, a manager or GC or head of department or legal counsel or junior counsel, we play a very important role in-house in advising policies to the top management, in devising policies, in reviewing policies in the best interest of the company, and we protect it. This morning, there was a PNG council you were talking about. I was very distinctly hearing your talk, and I was hearing about how you endeavor on behalf of your department to protect your trademark. So that was interesting as well. So you were talking about software, right? Software and how your R&D works. So again, software, having a software launched in a company to constantly monitor whether there is any trademark infringement, again, is an interesting move, and people do that. Next is, again, countries like India, we have heard about it a lot today, trans-border reputation, remedy of passing off, and again, the council who was there this morning, she said that there is 3 elements that needs to be proved for passing off, as usual, in the law of torts, 3 elements: misrepresentation, prevalence of reputation, as well as the damage caused. I'll not go through that again in detail. So internationally speaking, or generally speaking, on the other hand, if there is a case of trademark squatting, the most common solution advised by all of us, forget about trademark squatting. Say that you are part of a law firm, and then you get a client and a case. So I've been a part of a law firm as well, so what do we advise? We say litigate, right? We say just directly litigate. Come and file a case. And so sometimes I would advise companies to just let your lawyer decide whether to litigate or to negotiate or to do whatever. Because the lawyer possesses the skill and the aptitude probably to negotiate on your behalf and to nip the matter in the bud. There is a possibility to nip the matter in the bud. Well, the other thing someone would do is deregister. There are companies who have even deregistered themselves. Okay, I give it up. Why don't you deregister? Next is you enter into a bipartite agreement with the squatter and get back your trademark. And you know who has done this? Apple. Apple entered into a bipartite agreement with the trademark squatter and purchased its trademark back for $60 million, a whooping sum. So again, is this prudent? So if they are doing this, are our laws strong enough to leave alone obliterate, but even curb? Now, why I'm saying this? I'm a student of international law, and also I have been a student of comparative laws because I love comparative study of all the laws. And I'm also a practical person. And I always love to observe what nations do. At least in my experience in UAE, apart from trademark, if I am allowed to talk about something else apart from IP, because I'm sure you heard a lot of IP, let me talk about this. At least in UAE, when it came to the COVID pandemic, I know, forget about as a lawyer, but as a normal resident of this country, what UAE did to secure not only its citizens, but also residents. And I don't mind saying this, that at least by the press reports, no other country, I'm an Indian, I'm of Indian origin, and Asian, whatever you may call me, but no other country in the world has taken steps, I'm telling this in a public platform, like how UAE did. Everybody talks about their own financial structure, but UAE did go, much ahead and took number of measures, did vaccination drives, be it residents or nationals, and protected the interests of everyone who's living in UAE. It also has stringent laws, and I am for stringent laws. I am for stringent laws and not laws that relax. I am for stringent adjudicatory mechanism that operates as a deterrent mechanism. Not something that gives leverage to a criminal who says that I think I can sneak out of this. And not like a criminal who says, I can play the hide and seek game. No, I am for a stringent mechanism. As a lawyer, as an in-house counsel, I have devised stringent policies for the company, be it HR policy, be it trademarks, be it even whatever IPR, copyrights, and I have the experience, of course, I've been into the aviation sector. I was discussing this with a gentleman yesterday, that I've been a part of the aviation sector, and aviation sector agreements runs in 200 pages to 300 to even 1,000 pages when it comes to PPE agreements, public-private enterprise. So I feel it's a skill of a lawyer, whatever or how much you know, to understand that you know nothing, to be blank and to go through the contractual pages and then secure the interests of your company. So therefore, I would say that we have solutions to combat, but no tools to discourage or obliterating this act of trademark squatting. So what more can be done? Now, I propose to bifurcate my further discussion on obliterating the issue on what can be done at a macro level as well as a micro level, and some of it is already being done. But my suggestion at a macro level would be, who else besides WIPO can lead? A strategic move is the key. As I said earlier, having read the WIPO clauses, some of the clauses, to be frank and honest enough, meticulously, which actually advises on what can be done on trademark infringement, and it also advises on companies to promulgate domestic laws to curb trademark infringement. So who else other than WIPO can lead? So I would say that, advisably, WIPO has to devise stringent regulations through conventional clauses, and of course the state parties or the signatories should be able to abide. And of course the clauses should be rational and to aid effective implementation. What can be those strategic clauses? I think we could take it in the question and answer series, or I think it's quite professional enough because it has to be tailored clauses, and again, it is of international regime. So what would really make a difference is each country has to fortify its laws, its IP laws, in consonance with WIPO norms, treaties, and conventions. Now, why I'm saying this? In the light of the news that we have been hearing, and of course we have our legal gazettes and journals which have published this, we all know about the sad situation in Russia and Ukraine, where there are some prominent companies like McDonald's, Nike, etc., some of the companies who are in Russia. They imposed sanction on Russia and said that we no longer want to be a part of this because I do not know. So they are not in line with the thoughts like Russia, whatever reason. I'll not go into that. But the thing is, what Russia did in response, after the sanctions were being imposed, Russia promulgated a legislation saying that we have got a lawyer from Russia, so he's the one who should teach us more about it. So it promulgated a legislation saying that now you can, register your trademarks by whatever name. And there was one of the companies which registered a trademark just like McDonald's. But the difference is, McDonald's is an M, and the other trademark is like a B. There's another company which launched a trademark just like Nike. No changes. So the question, how far is your domestic regulations, directives, whatever, legislations, promulgations, whatever name you call, how far is it effective? As a lawyer, or as you all are lawyers, in-house counsels, or even whatever designations part of big organizations, or even international organizations, what is your advice to this? I will take it up in the question and answer session, no problem. I'll do that. But this is something for us to think about at the back of our minds. Are we effective at whatever we do and wherever we are? Whatever little we do and wherever we are we effective? Are we utilizing the knowledge that we have in securing the rights of probably your client or your company? Well, the next thing is a tracking system. My learned friend already, he discussed about it. And yet another thing is, what Apple did. This is, again, I think most companies do also. Apple tried to shield itself and safeguard its trademark by listing all its trademark on its website, of course, with certain policy specifications adumbrated there. Next is, again, coming back to my opinion, lastly, it depends, again, I would like to reiterate and thump upon this aspect. Rather than just talking about the existing laws, which you already know, the thing is, it largely depends upon legal counsels like us with eagle-eye vision. I'm sure, eagle-eye vision, where you can really gauge something from a distance, interpret laws, interpretation of laws Avoid, while you're drafting, wide interpretation of the particular clauses where we have got distinguished skill to foresee and certainly thwart certain conflicts, of course, in your expertise and support your organization or client. And now I would like to leave you with a question. What about squatting of dead trademarks? Before I close, I'd like to go even through the WIPO's definition of trademark squatting, so that probably we would take it up at the question and answer session. Now, WIPO's definition of trademark squatting is the registration or use of a generally well-known foreign trademark that is not registered in the country or is invalid as a result of non-use. In the light of this, I pose a question to you. What can be done in case of squatting of dead trademarks that were once upon a time famous and now no longer in use? I'm not talking about resurrect the dead trademark or refile or that. What can be done to obliterate trademark squatting of once upon a time famous trademarks, that are dead today? And of course, I did not talk about the Madrid Protocol because already it was discussed this morning, and just to brush over that aspect as well, because I feel it is incomplete without me mentioning about the Madrid Protocol, the famous Madrid Protocol. We all know that it covers 112 countries. So if you register your trademark under the Madrid Protocol, you conveniently cover 112 countries there. And apart from that, yet another thing what the corporate councils can do is register your trademark in maximum jurisdictions, at least by that I mean, but at least in key jurisdictions where you anticipate launching your business. So that's one of the things. Well, ladies and gentlemen, this is Henrietta Newton-Martin with you, and I think question and answer can be taken towards the end of the session. Thank you so much for your patient listening.
Thank you so much, Henrietta. It was a great presentation. Now, our next speaker is